Now from our powerhouse legal team, former federal prosecutor Gene Rossi, trial attorney Monique Pressley, who also represented at one point Bill Cosby, and Benjamin Chu, former co-lead counsel for Johnny Depp during his defamation trial against Amber Heard. Monique, I want to get right to this pattern. I know obviously in a RICO case, you got to show a pattern of different behavior, these so-called predicate crimes. But we're hearing a lot about the pattern of the freak-offs. Multiple witnesses now testifying to this effect in these hotel nights or whatever it might be. Is there a compounding effect that is useful for the prosecution on that issue?
Not to me, not from what we've seen so far. I mean, if someone who, when they're involved in an intimate relationship, likes to have candles in the room, likes to have some sort of oil, some sort of lubricant, some sort of music, some sort of lighting, that seems to be what they're establishing, that is his pattern for what he likes during those interactions. But that's not criminal. And until they show that that's aiding in a particular crime, then what we've got is dating pleasures. And I am concerned, frankly, Laura, that a lot of what we are hearing could be the makings of crimes for millions of people all across this country if what the prosecution is saying thus far is what we are supposed to accept as a criminal enterprise.
Interesting point. The idea of the question lingering, why not charge others with this? That might be a question the jurors are asking themselves to some degree. But Ben, how about this theme of money and financial dependence of some of the witnesses? I mean, this person, Jane, who's been testifying, says that Diddy would frequently give her between $5,000 and $20,000 because her source of income, as she testified, was affected after she then prioritized their relationship. What is the prosecution trying to get at when they're addressing these so-called allowances? Is it financial independence as a way of coercion?
Yeah, I think that's part of it. I think why Jane is so powerful a witness is that she has the same arc of the relationship with Diddy that Cassie Ventura had. It started out as a friendship, it became love, it became romantic, and then he allegedly converted it into more coercion and having sex with other people, so I do think, I think Monique's point is outstanding, but I also think that they are getting some of the coercion that they're going to need for the RICO count.
So how about this moment in court? I mean, when I saw it, I was taken aback when the judge scolded counsel, obviously scolding Diddy, about nodding at the jury, nodding and also looking directly at them. It's not the first time. You heard Kara Scannell say, not the first time he's been nodding, but you say that's a really big moment because it's a very big mistake for a defendant to do that. Tell me why.
For 27 years, I was a prosecutor, and whenever the opposing party and the defendant made faces to the jury or nodded, I almost did the Toyota commercial and jumped to the sky because jurors hate when that happens. They hate it when the prosecutors do it.
They hate being looked at.
Absolutely. You're invading their space. And I remember telling Ben that one of the key moments of his trial is when Amber Heard was looking at the jury after every question. They don't mind you looking at the jury, but that was sort of invading. And I said a couple shows ago that when I was a prosecutor, I always assigned somebody, in a big case, not that small, I always said, watch the jury. But I never said to the defendant, watch the jury. So he is antagonizing the jury, but I gotta sort of.
If he is nodding at, you're saying, okay.
Yeah, but let's assume he was. I have to criticize the judge a little bit. If he allowed it to happen and then had an epiphany, you know, he should have done it the first time Diddy did that with that security guy. He should have admonished Diddy then. But
well, actually, I think that's an interesting point, particularly because you guys should know the number of sidebars that happen in this trial it's pretty stunning. I mean, when there's momentum happening from a good questioning and the witnesses has their back against the ropes, there's a sidebar to obviously slow it down as a tactic. There's also a number of moments when they are conversing with the judge, and one would presume at earlier moments during the trial, the judge could have addressed what he was actively seeing. But then, Monique, a defendant, people might think, they can't react. They've got to be a cardboard figure. They're not able to do anything if they're being accused of horrific crimes, etc. What is that line between a human reaction and honoring the judge's order not to, as you've said, antagonize by looking?
So first, the defendant is the most important person at that table. And they're the one with their life on the line because we're talking about liberty interest here in this case. They have every right to, not just in addition to whomever the defense also has looking at the jury, they have a right to look at the jury. If they notice something that can aid in their case, if they notice a juror slipping, a juror sleeping, a juror questioning, a juror frowning, and want to let their attorneys know that it's happening, the reason why they're there is so they can see. Now, yes, there's a line, and yes, you have to coach them beforehand. You might hear this today, and this is going to be hard to take, and here's the way I'm going to need you to respond to that, and here's how we prep for that. So that's the work of preparing for trial. But in any trial that I've been in, the voice I needed to hear the most, the voice that was most important throughout witness testimony, was my client.
A really important point. And of course, you have right to confront your accusers, and the threat to remove him from the room would be a pretty drastic one, and one that would leave the jurors asking questions and possibly, if convicted, an appellate issue. But let me just ask you about this witness. She went by the name of Bonna. She was a friend of Cassie Ventura, still is, she testified. I gotta tell you, sitting in that courtroom, the defense was scoring a lot of points with her. They talked about the civil lawsuits, about a financial motive. The dates were wrong. There were some discrepancies, some memory issues. The idea of the government's notes. There were a lot of moments where even in the audience, people were thinking, why did the prosecution call this person who had such baggage on this issue? Was it a mistake?
I think it was a mistake. I think they didn't need her.
But why didn't they need her? Because she talked about the balcony. Why is that not important to the RICO case?
Well, it is. So I could see them wanting to get that, but they really needed to nail that down. You know, we were talking about this before. You get the timing nailed down. For example, if she wasn't sure about the date, then that should have been established in the direct. It shouldn't come out, as Jean said, in the cross, because then it makes her look guilty. I think it destroyed her testimony. I haven't been a great fan of the cross-examinations generally. This one was good.
And by the way, there was a moment, I'll finish your point, but there was a moment at the very beginning of the cross when Westmoreland asked the question about the immunity and said, you only can be prosecuted if you're lying, right? Yes. Who gets to decide whether you're lying?
Well, the prosecutor decides whether she's telling the truth. But here's the thing, and I hate to be a Monday morning quarterback for the prosecutors or for the defense, but this is an example, in my view, of a lack of preparation. She was a Jekyll and Hyde witness. When she probably prepped, she was good, but on the stand, if they didn't pin down that date, you can't rehabilitate a witness after you've been crushed on cross on the date. It's too late.
It can't be, it happened someday when they said it happened on a particular day.